All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Welcome. Good morning. We are here for oral argument today in case number CA JV21 0190. Counsel with COVID, we're arguing from our respective tables. You can take off your mask if you'd like. I have mine off. Judge McMurray has his on. Each side has 20 minutes for oral argument. The appellant may reserve time. I would just ask that you keep track of that yourself. There should be a clock on the podium. The proceedings are being recorded and live streamed, so please introduce yourself and your client. We've read the briefs, conferenced the case, and are familiar with the arguments raised. Please keep that in mind when making your arguments. So with that, you may proceed, counsel.
Thank you, Your Honor. May it please the Court, my name is Dawn Williams, and I represent the Department of Child Safety, and I'd like to reserve 5 minutes for rebuttal. We're here today because the juvenile court had 3 options for terminating parental rights in this case. All 3 of the grounds for termination had some sort of temporal aspect. The problem that we have here is that the court applied the same temporal aspect to the 3rd ground as it did to the first 2, which was an error. ARS 8533B11 provides for a requirement that the court find that the parent is currently unable to discharge parental responsibilities. And here the court articulated that currently means at the present time, but then went on to make findings indicating that the court was looking at the parent's ability to parent in the near future, which is an element of the time and care ground under 8533B8B.
Didn't the court specifically find that the parents were able to parent?
The court did. The court explicitly found that the parents were able to parent or were able to discharge parental responsibilities.
If that's the case, why is the dependency still ongoing?
The court also found that the dependency continues to exist. That's part of the problem, is that the court's findings were incongruous. The court found both that the parents were currently able to parent and that the child was in need of a parent and had no parent willing to exercise or capable of exercising parental responsibilities. Those 2 findings they're not compatible. And that's the problem that we have here. That's why DCS raised this appeal.
What if it were just a question of, we need 5 days because parents are moving, we're going to keep the dependency in place for a week or 2 weeks? Is that necessarily inconsistent with the finding that the parents are currently able to parent?
I think we'd be in a different posture if that were the case. I think the problem here is that it wasn't a 5-day issue. It was an issue of the parents had repeatedly relapsed every time there was a stressful event in their lives. And so when the department first moved to terminate their parental rights, their response was to relapse and use, I think they described it as a whole lot of meth.
But assuming the court has found that we think the parents are in a position that they've overcome those issues, wouldn't it be then up to maybe the parents could have come in and said, you need to end this dependency. You found that we're currently able to parent. But if there's evidence that supports the court's ruling there, it seems like they would have a basis for coming in and arguing the dependency should end. But that issue doesn't seem to be before us. No one has raised that.
The parents have not requested that they did not at this time request that the dependency be dismissed.
But does that necessarily then mean that the court abused its discretion by finding that they were currently able to parent? The fact that they didn't come in and appeal that?
It's not the fact that they didn't come in and appeal. It's the fact that the court made 2 contradictory findings. And as we mentioned in our reply brief, had the court just found that DCS hadn't proved the elements of the ground, we wouldn't be here today. It's the fact that the court made an affirmative finding that these parents are able to discharge their parental responsibilities, coupled with a finding that demonstrated the court had the same concerns as the department, that these parents needed to finish their services to ensure that they wouldn't suffer another relapse. And that was exactly the department's concern. And that's why the department brought the severance in the first place, that these parents have a longstanding history of substance abuse and relapse. And the fact that they had been sober for approximately 6 months at the time of the finding is great, and the department is happy for them and wish that they could maintain that sobriety. But unfortunately, this child has already waited most of her life for the parents to get their act together and address their substance abuse. The fact remains that the parents hadn't completed their substance abuse treatment and so hadn't addressed the triggers that led to the relapse. And so until they do that, they're not going to be able to provide a safe home for this child.
How long ago was this finding made?
The finding was made in May of this year.
So that was approximately 7 months ago.
Mm-hmm.
And the judge said it was going to be a short fuse. What's going on with the case? Can you tell us?
That's not a part of the record here, but
I realize that, but that's why I'm asking you if you
since
can
the ruling, both parents have provided tests that are positive for methamphetamine. It's my understanding that mother's test is awaiting a confirmation of that positive test.
So the appeal is not moot. That's where I was going with all of that.
As far as the department is concerned, it's not moot at this time.
As a practical matter, since the dependency is ongoing, what will change if we vacate the court's ruling as opposed to the department goes forward now saying there's a positive test? Is there something as a practical matter that's going to be different depending on the outcome of how we rule?
The difference in part will be some guidance in terms of how to apply this ground and whether currently really means at the immediate time, as the department has read the statute to read. In addition, by denying the department's motion, the court reset the case plan goal to family reunification, obligating the department to continue to provide services to the family and visitation between the parents and the child. So if this court were to reverse the juvenile court's finding, the case plan goal would return to severance and adoption, and we would go back to the juvenile court to finish litigating the severance motion.
Would we do anything more than just vacate? I mean, how could we come in and say you've necessarily, it seems like the court just made an inconsistent ruling. Either the court should have said they're not currently able to, and currently able means as of this particular minute, or okay, they were currently able. I'm interpreting it to mean it can be in a few days. But if we're just going to vacate the ruling, the court seemed to say they are currently able to parent.
Right.
So wouldn't we just vacate? We're not going to reverse and say no, they were not able to parent. We wouldn't have a basis for reversing and saying no, you need to sever. All we can really do is vacate. Would you agree with that?
I would agree with that. And then the court didn't reach the best interest finding because it had determined that department hadn't proved any of the grounds.
If we're vacating, you're saying by vacating, the plan would still be in place of the reunification would not be on the table, so to speak.
The department would ask the court to then make a best interest finding based on the pending termination motion.
Well, except if we vacate it. So then it would go back and it would say, we vacated and now it's been 7 months. So have a new hearing and do consistent findings and make a determination on whether or not the department has proven their case. Isn't that what we would do?
Yes. And that's what we're asking the court to do, to ask the juvenile court to make findings that are consistent with the statute.
But I guess my question was, as a practical matter, how will it be any different either way if we just, even if we were to affirm this ruling saying there was evidence that supports the court's denial of severance, now you go in and say there's a positive test. I'm not sure as a practical matter that there's much of a difference in us vacating or simply saying there was evidence to support it, but that just means there's a dependency and it appears that there's now a reason to go forward with the severance again.
The difference is mostly procedural in that it would require the department then to go and file a new motion to terminate parental rights, which would add additional delay for this child who's been in out-of-home care essentially for about 4 years. So the department hasn't moved toward any kind of liberalized contact between the parents and the child as far as I'm aware. I'm not the trial attorney, so the parents' attorneys may have more information about that.
If the court had, or if parents had cross-appealed and said the court erred by not ending the dependency, the state's position on that would have been no, and that you have to reverse the finding there.
We would have argued that reasonable evidence does support the court's finding that the child remains dependent.
Remains in the dependency. Okay.
Mhm.
I thought the statute said that you have to dismiss the petition if the court doesn't find that the basis for the severance has been proved. Isn't that what the statute says?
It says dismiss the severance petition if you're...
It doesn't say severance, it says the petition.
Right, but that's in the statutes governing proceeding by severance by petition, and this was a severance by motion. So the underlying dependency proceeding would continue.
And that's the distinction that you draw because of the rule that says that?
Because of the differing statutes. This court has recognized in the past that the statutes governing severance by petition are slightly different than the statutes governing severance by motion. So since the motion arises in an ongoing dependency, that dependency continues. Had it been a severance petition, that petition action would be dismissed. And if the department had filed a severance petition while there was an ongoing dependency, the dismissal of that severance petition also wouldn't affect the underlying dependency. That would be a separate finding. I think it's important to note that the juvenile court here recognized that the parents were making progress, but found that even with that progress, the parents were still unable to parent at that time. The court couldn't even return the child to their physical custody and maintain a dependency. They weren't even ready for that level of parenting. And without that finding, the court's finding that they were currently able to discharge parental responsibilities really doesn't make any sense. We're left with incompatible findings that demonstrate the court really lacked an understanding of this ground. In fact, at closing argument, the court indicated that the court wasn't familiar with the ground and didn't know that the ground existed. And so that fact indicates that, and the court requested additional information. So that's why the parties provided additional memorandum decisions to the court to try to assist the court in making this finding. The department recognizes that this isn't a ground that gets used as often as some of the others, although we're seeing it increase a lot as the department is making a concerted effort to reunify families. If that's done too quickly, what happens here happens in other cases where the family, once the pressures of reunification are there without the supports from the department, they relapse and the child comes back into care. And that's what we're trying to avoid. This child has a right to some sort of permanency that she hasn't had, and the parents have essentially had two dependencies to remedy their substance abuse issues, and they haven't done so yet. And so requiring the child to wait for them to step up and take the necessary actions really isn't fair to the child.
Would the court have had any flexibility if the parents had come in and said, we need 3 more weeks, we'd like to continue the hearing for three more weeks, where whatever the basis for the dependency, let's say we're a different ground, and that's going to be remedying within 3 weeks or within a month, we'd like to continue this. Would the department then come in and say, no, you can't continue it, it's been too long, or I assume maybe a case-by-case analysis on that?
Right. In this case, the department likely would have objected to a continuance, but had the court granted the continuance, that's an abuse of the discretion standard. The department likely wouldn't have challenged it. The issue here is that the court misapplied plain language of the law. The department didn't appeal from the court's findings on the substance abuse or time and care grounds. The department recognized that there was sufficient evidence to support the court's finding that the parents' substance abuse may not continue for a prolonged indeterminate period if they finish their treatment, that they may be able to parent in the near future if they finish their treatment. The department acknowledged that. The department only challenged this particular ground because of the incongruous application of the plain language of B11. B11 doesn't have that wiggle room that the other two statutes do regarding the near future.
Can I, as a follow-up to one of the questions Judge Catani asked you, if Judge Lang had said, I don't think you can currently parent, but I don't think it's in the best interest of the child to grant this severance, that's not an appealable order from the department's perspective, is it?
The department would not have sought appeal from an order like that.
So we're talking, the only distinction here is It's clear Judge Lang wanted to give these parents more time based apparently on the bond of the child to the parents, but he simply put it in the wrong category. I mean, he could have put it in the best interest category, but he didn't. He put it in the severance category, which, as you pointed out, is in your briefing, is inconsistent with his later finding. Did I
Correct.
state that correctly?
Yes, that's correct. So the court made an error of law that didn't have to be made.
But it goes back to what Judge Catani is saying is, yeah, but in our practical context, you're going to go, if we send it back, you're going to be right back where we are as of today, but it should be a hearing, shouldn't it, today? It's not just a matter of him dotting I's and crossing T's 7 months ago.
No, we would have to have a new hearing because of the change in circumstances.
But if this had been a special action the week after the ruling, and we were to say it's inconsistent, I mean, there would have been nothing to prevented the Superior Court from simply saying, well, I find it's in the best interest of the child to continue the dependency. That you wouldn't have challenged that had we sent it back. Look, this ruling's inconsistent, but if there's it seems clear in reading it that that's what the court was saying. It's in the best interest of the child to continue the dependency. So why go through why necessarily reverse something like that? Just to make sure the findings are accurate is what you're suggesting.
Yes, and because this is a ground that doesn't have a lot of case support in terms of how the juvenile court should interpret and apply it. And so to the extent that we could provide some clarity, that would also be a useful piece for the juvenile court.
But should we provide clarity in saying if you don't want to reverse, if you don't want to end the dependency, you can just make the finding based on best interests?
Or make a finding simply that the department hadn't proved the ground, either way. But when the court makes an affirmative finding that the parents are able to discharge parental responsibilities and then also finds that they're not able to discharge parental responsibilities, we have a problem. And the department really has no way to go forward from there.
I know under the proposed new rule that's pending before the Arizona Supreme Court today, that this would be a final appealable order. But I'm not sure it's a final appealable order, is it?
That's really undetermined. There was one case that suggested that it was not an appealable order, but there are decades of history of cases where this court has addressed them as appealable orders. So it's really unclear. But if this court determines that it's not an appealable order, it could, of course, exercise special action jurisdiction. And that's what we would ask the court to do.
Or given the fact if it's still ongoing, we could just dismiss the appeal as not an appealable order and let you all fight it out back in front of Judge Lang, right?
That's also an option.
Okay.
If I may, I'll reserve the remainder of my time.
Thank you. Counsel.
Thank you. My name is Thomas Vierling, and I'm the attorney for the appellee Roger B. I'm going to reserve some time for mother's attorney as well. It's our position, following up on the last statement, that this is not a final appealable order. There is nothing final about this order.
But in the current rule proposal, it is clearly under the new rule, if adopted, and we'll find that out this afternoon, that it isn't a final appealable order.
That's correct, but it was not the rule at the time this litigation started. And the case AR states that, quote, further, the ruling is not a final order because mother's dependency case is still ongoing in the juvenile court, end quote. And that's exactly what is being talked about here. There is no finality. In fact, the juvenile court didn't even address the best interest analysis. The status quo was maintained.
Mr. Vierling, he wouldn't have addressed the best interest because he didn't find the severance base.
That's correct. And that's why it's not an appealable order. There are many issues that would need to be addressed.
But if it's an inconsistent ruling on its face, why wouldn't we accept special action jurisdiction and address it to point that out?
Well, certainly the court has the ability to do that and has in the past. In the case AR, that's what the court did. Brianna J., which is a similar type case under Rule 59 for return of child to parent. The court went through a similar type analysis, determining that that was not a final appealable order, and addressed special action and then denied in that case as well. The times where there are final appealable orders, there is resolution of issues. For instance, a finding of dependency, where the child is now a ward of the court. That's a final order, but this is not. We would ask the court to simply dismiss the appeal. This appeal has tied the hands of the juvenile court for months and has...
Why would it have prevented parents from coming in and saying, you need to end the dependency?
Well, it appears that the court took the position that it could not address this.
But was there something that prevented, what possibly would have prevented the parents from coming in and saying, look, we've now, you said we're currently able to parent, the basis was drug use, we're drug-free, please end the dependency. You're saying the court could not have done that?
Yeah, possibly, because then it would have mooted the appeal. And since this was not a special action, this is an appeal. And they would have mooted the appeal.
Yeah, but there was a time between the finding of the court and the notice of appeal. The parents could have moved it during that period of time, right?
They could have, but they did not. It appears in reading Judge Lang's decision that Judge Lang took the matter under advisement, made his ruling, and set these issues all to be addressed at the hearing that was already on the calendar for the parents and the parties to come in and address whether the dependency should be dismissed or whether the children should be returned at that time.
Did Judge Lang say that, on whether the dependency should be dismissed?
No, but that would have been an issue that could have been raised had the appeal not been filed. In addition, the factors that were used in the analysis by
But certainly parents could have filed a special action at that point, even assuming the appeal is pending. Parents could have filed a special action urging the court to, or filed a motion to dismiss the appeal and filed a special action saying there's no basis for continuing the dependency. Seems like there were options for parents to challenge the dependency.
Correct. There are some options that were not done. The state is arguing that there's inconsistency in the two findings. One is the denial of severance, and second, in keeping the case open and setting it for the next hearing. The ruling from Judge Lang is very specific in the severance findings, that he found that these parents were currently able to parent, and he listed the facts that were specific as to why he made that finding. And then he made a finding to keep the case open, which was a general finding and not as specific. We would ask the court to, if the court does take this matter under special action, to credit the specific findings on severance, that those were the specific findings of the court, and that the findings to keep the case open or not dismiss the case may have been the error, not the severance, because the specific findings of Judge Lang as to severance, as opposed to the later findings about getting them an opportunity to keep working on the case.
That sounds pretty much like you're asking us to do a Houdini here, to say, oh, this part of this order, in the same order, we're going to follow, but this part we're not going to follow. Seriously? That's where you want us to draw the line?
Well, we believe that the specific findings on denial of severance are the holding of the court in terms of a severance motion. The other findings are ongoing case management findings that are not related to the findings as to the severance.
So you're saying they're not necessarily inconsistent?
Well, they may not be inconsistent. There's a different burden of proof involved in keeping the dependency case open. That's a preponderance of the evidence as opposed to clear and convincing, which was the standard the state had to prove in order to approve severance.
But we're talking about a very specific, are these parents currently able to parent? I don't see how that's a burden of proof issue.
Well, and Judge Lang found they were in the severance.
And then he said they're not, by keeping the dependency open. That seems pretty inconsistent to me.
It does sound inconsistent, but it's at a different level that he may have found under the preponderance of the evidence standard. And
Did he say that in his order? Did he draw anything you're saying now, did he draw any of that distinction in his order?
He did not list the burden of proofs. But there are cases where the court does assume the court applied the law correctly in certain contexts when they are silent.
And if we vacate the ruling, how as a practical matter will that, in your view, change the proceedings going forward?
Well, the dependency case is open. The litigation resumes. The state can always file a motion for severance again, which is their prerogative.
Would they need to do that if we vacate the previous order? If we vacate the previous order, doesn't that just put all parties back at the same time? We just say, we vacate and say, have a new hearing.
Correct.
And make correct factual finding.
Right, and it wouldn't be the need for a new hearing because the Shella H case says it's based on the circumstances at the time the court hears the matter, the juvenile court hears the matter. So if the court vacates the order and sends it back, there would need to be a new hearing, and Judge Lang would have to take...
But they don't need to file a new petition. The court just needs to schedule a hearing on severance if we vacate.
If the court vacates and then the motion is still in place, they would not need to file a new motion.
The only difference is how much time will be involved and how many hoops DCS, the state needs to go through. And if the best interests of the child are a concern for us, the length of time in care, would that counsel in favor of saying just go back, put you back in the same position you were before the ruling?
There would be less time. Parties would not need to be served. There wouldn't be the need for initial hearings. The court could then just reschedule a hearing.
And why doesn't that make sense, given what seems to be the inconsistency in the ruling? They're currently able, but they're not currently able to end the dependency.
Well, because we believe the correct decision was made on the severance. The court found these parents could parent currently, and the judge discussed that in the decision.
But then they didn't challenge the dependency, so they seem to be acknowledging there's a reason for continuing the dependency.
That's right, and there was no appeal from that. There were no motions to dismiss. So we are in a position where the case is still open. So if the court sends it back, Judge Lang could readdress all these issues. And I'd like to give my co-counsel an opportunity. Well, not co-counsel, the other parent.
Good morning. May it please the court. My name is Jamie Heller, and I work with the Office of the Legal Defender. We represent appellee mother Mariah V. With regard to this case, if the court does address the substantive issue, it's our opinion that the substantive issue is simple in this case. It's whether the juvenile court properly found that the Department of Child Safety failed to meet its burden of proof by clear and convincing evidence regarding whether the parents were currently unable to discharge their parental responsibilities. It seems like the big issue in this case, the questions have been on, are the court's finding that the parent failed to meet, or the department failed to meet its burden of proof by clear and convincing evidence, but then it also made some specific findings of fact, including that the parents were currently able to discharge parental responsibilities. I'd like to address the specific rule that goes in conjunction with the statute when the department files a motion. So the specific rule is Rule 66. Rule 66F3 specifically makes clear that when the court denies a termination or petition, it is supposed to find that the department failed to meet its burden of proof, which it did in this case, and order the parties to submit a revised case plan prior to this pendency review hearing. The rule does not require the juvenile court to automatically dismiss a dependency when it denies a termination based on the B11 ground.
Hold on. If the court says, I think the parents are currently able to parent, Are you telling me that the parents aren't entitled to the child?
I'm not saying that the parents aren't entitled to the child. I'm explaining the facts of the case before the court, and the issue before the court was whether or not the department met its burden of proof to terminate these parental rights. And the juvenile court found no, they didn't meet their burden of proof.
I admittedly, I mean, that's been fairly discussed here this morning, but it's based on the ability of the parents to currently parent. And if the parents could currently parent, they're entitled to the child.
That's true. If the parents are currently able to parent, they're entitled to the child.
And if they're not currently able to parent, then the department has proved its case.
The court in this case didn't find that, and I think one of the reasons...
Hold on, answer the question.
Okay.
If they currently couldn't parent the child, then the department has proved its case.
If the department proved that by clear and convincing evidence, yes.
So your sole basis on us, this determination goes on whether or not the court was finding by preponderance of the evidence or clear and convincing evidence.
Yes.
Is there anything in this order that would indicate that that Judge Lang believed that was a distinction in this case?
No. In this case, Judge Lang indicated that the department's burden of proof was by clear and convincing evidence. It then stated specific facts that it found, which were consistent with ARS 8-533D, which required Judge Lane to take into consideration the availability of reunification services and the actual reunification services the parents participated in. So subsection D of this same severance statute required Judge Lang to take into consideration services, and that's what Judge Lang did in this case. The findings that Judge Lang did make, he didn't indicate what standard of proof he used. He wasn't required to. In this case, Judge Lang could have just said, I deny the severance, period. The rules didn't require Judge Lang to make any specific findings. The fact that Judge Lang did make specific findings in this case were consistent under subsection D because he was required to take into consideration the availability of reunification services and the parents' progress. The legislature made clear in the dependency statute 8.8 for B2 that at the time of a dependency, when the burden of proof is only by preponderance of the evidence, if the juvenile court finds the department failed to meet its burden of proof, at that time it is to dismiss the dependency petition. There's nothing similar in the statute here that requires the juvenile court to automatically return the children and dismiss a dependency when the court denies severance based on this B11 ground. If the legislature wanted that to be the result, it could have done that, and then it would have been crystal clear, as it did in the corresponding dependency statute, when a dependency is at issue in a case. But here, that wasn't the result.
So you're suggesting then that DCS had the option, after Judge Lang's ruling, to come in and say, we want to schedule the conference for 30 days from now or 2 weeks from now. I understand we don't want to automatically transfer a child the hour after the severance has been denied. Presumably there's some kind of transition period, and presumably that's the basis for this rule setting a hearing. So if DCS had come in at that point and said we want to have a hearing in 2 weeks or 3 weeks, if they come in, sorry for a very long question, but if they come in at that point and say we want a hearing, do they have to file a new petition to sever? If they come in and say, look, they still are testing positive for drugs, you're saying DCS at that point would nevertheless have to file a new petition to sever?
So it depends. In this case, it was a severance motion. So the rules required the court, which I don't believe the court did in this case, to order the parties to submit revised case plans. I'm not the trial attorney in the case, so I don't know if those revised case plans were submitted, but it's possible the department could have asked for the case plan to remain severance, and then it would be up to the judge whether or not it allowed it. At any point in time, the department is able to file a severance petition. It doesn't need the court's permission to file the petition. If the case plan remained severance and adoption, it could have again filed another motion and proceeded on another severance case in the facts of this case.
Ms. Heller, I'd like to ask you a couple of questions. First of all, do you agree with Ms. Williams that this case is ongoing even though it's been 7 months since the order was issued?
Yes, the case is ongoing. I did want to point out to the court, it's my understanding that the parents have continued providing negative urinalysis tests, and the only issue with regard to substance abuse is regarding a hair follicle, and it's my understanding that the department has not provided the appropriate disclosure to the parents' attorneys yet to be able to determine whether or not that confirmation result is positive or negative. With regard
I just wanted to make sure that, I don't want to get too much in the weeds on
Yeah.
that, but I just wanted to make sure that it
Yes.
hasn't been mooted. That was my question.
Yes.
And then the second thing I wanted to ask you about that is, even though the department appealed, could they nonetheless have filed a new severance petition?
I don't believe they could have, because the juvenile rules regarding this court's jurisdiction doesn't allow the juvenile court to make any decisions that would moot this appeal. And so I don't think, could they have done it?
But why would
Maybe.
it-
I don't know if the court would have accepted it or set hearings on it.
Why would it necessarily moot the appeal if the only possible outcome of the appeal is to continue I guess you're saying if this court had agreed and just dismissed it, then, or said there should have been a severance, it seems like that would be an extraordinary ruling from our part to say, no, you necessarily have to rule. It seems like the only possible result would be to say you have to vacate that ruling. We wouldn't come in and say, we're going to accept this part of your ruling and not that part of the ruling. So it seems like the only possible result of an appeal would be to continue. The dependency is going to go on no matter what. And it seems like proceedings in that dependency could have gone forward, or sorry for just rambling.
No, so I agree that if this court agrees with the department's position, then it would have vacated the court's termination and the court would have had to hold another hearing, which, as far as how that would relate to a new severance petition,
But that means there's going to be an ongoing dependency.
No matter what.
And there is a dependency, so why not make some motions regarding the dependency saying, look, this was the issue on appeal that has nothing to do with whether the dependency needs to continue now.
That's a very good point. I can't explain to this court why the trial attorneys in this case didn't proceed with trying to move the case forward. But just in practice, it's my understanding that parties believe their hands are tied when an appeal is going on with regard to, I believe it's Rule 104, as to what the juvenile court is allowed to do. So unfortunately, I think sometimes that the trial attorneys believe that they're not able to move forward with something like moving to return the child home or dismiss the dependency when the appeal is going on, because the court ruling on that, I believe, is not consistent with what the current juvenile court rule is regarding the juvenile court's authority while an appeal is pending.
And it's mother's position, just like father's, that this is not an appealable order.
Yes.
This was not an appealable.
Mother didn't raise it in her brief, but she joins in she definitely joins in father's argument with regard to that. The only other point I did want to make is the Department of Child Safety did raise various memorandum decision as persuasive authority. I see my time is up, so I guess I will stop.
You can finish your sentence.
Okay. As persuasive authority in this case, and just wanted to point out that all those memorandum decisions are distinguishable from this case. Procedurally, in those cases, the juvenile court found that the department met its burden of proof. Therefore, pursuant to Rule 66, was required to make specific findings to support its ruling, and this court on appeal affirmed all determinations under the B11 ground and found reasonable evidence was in the record to support those findings, and it highlights the importance to allow the juvenile court flexibility in determining the specific facts of each case. Thank you.
Thank you, Ms. Heller. Ms. Williams, you have 3 minutes and 21 seconds.
Thank you, Your Honor. Just briefly to address a couple of issues. First, regarding whether or not this is a final order. The department has conceded that that's up for debate, that it's not entirely clear. But I would point out that in this court's ruling in Brianna J. discussing what makes a final order, one of the ideas was that an order that isn't final returns the parties to the status quo. And as I mentioned here, the status quo wasn't restored because we had a different case plan goal when we went back to court after the denial of the severance action. So I think that leans in favor of this being a final order. In addition, the court has found that dependency orders, orders adjudicating a child dependent, are a final order, even though obviously the dependency continues after that finding. So the fact that a dependency continues after a finding isn't dispositive in terms of whether or not an order is final. I would point out again that the department has never said that the juvenile court is required to terminate a dependency every time the B11 ground isn't found. In most cases, when the court finds that the B11 ground isn't proved, that doesn't necessarily mean that there's no longer a dependency. But I would note here that the juvenile court on page 6 of its ruling clearly affirmed its prior dependency findings. And the rule requires that if the court at any dependency review finds that a child is no longer dependent, the court has to dismiss the dependency petition at that review hearing. And that's regardless of whether there's been a transition or if the child is out of home. If the court makes that finding, the dependency is dismissed, and the court didn't and couldn't do that here.
But doesn't the court have to set a hearing? The kids aren't returned the minute the severance is denied. It sets a hearing for 2 weeks later?
Not typically. Typically, if the court finds at a hearing that the child is not dependent, the court dismisses the dependency and the child is picked up that day. What we strive to achieve is to have reunification occur before we get to the point of dismissal, which is what we tried to do, or what we did in the first dependency here. The child was returned in October, and the dependency wasn't dismissed until December. That's the ideal, so that we have time for the child to be in the home while still receiving services to make sure that that placement's going to stay.
But when the state's arguing that the severance needs to go forward, and the court disagrees, don't you agree that there would need to be a hearing at that point to decide how to transition the child?
Yes, and especially at this point, because there has been several months in the interim, there have been changed circumstances, the department would absolutely want a hearing on whether or not, especially if the court was considering dismissing the dependency at this point. And I would point out, too, that even the mother's trial testimony reflected that she understood she needed to participate in services going forward before the dependency could be dismissed or the child could be returned. So I think that demonstrates that the parents did understand that they weren't quite there yet. And with that, I see that I'm out of time.
Thank you, counsel, and thank you both for your arguments today. We will take this matter under advisement and issue a decision in due course. With that, we are adjourned.